I'm Sandy Steinman, President of Background Checks Express, your one-stop source for accurate, accessible, and affordable background checking. Because of the amazing increase in costly lawsuits against employers for violations of the Fair Credit Reporting Act in their background checking, we've decided to review the requirements that employers must follow. Last week, we looked at the pre-adverse notice that must be sent to applicants that you do not intend to hire and whose background checks result may have played some part in your decision. This week, we're going to look at the fourth requirement, which is the final adverse action notice. Let's assume that you have an applicant that you decided not to hire, and the background check that you ran may have played some part in your decision. Let's also assume that you watched last week's video and wanting to comply with the Fair Credit Reporting Act and wanting to stay out of court, sent the pre-adverse notice to the applicant informing him or her that there may not be an employment offer forthcoming, and sent the applicant a copy of the background report and a copy of the document titled Your Rights under the FCRA. Now, 5 days have passed and you've not heard a word from the applicant, and you sigh a big old sigh of relief. You've done your job and complied with the Fair Credit Reporting Act, right? Well, not so fast. There's one more step, and it's called the adverse action notice. In this notice, you inform the applicant that you've made a final decision not to make an employment offer, and include in the notice again the contact information for the company that provided the background report, and you must once again send the applicant a copy of his rights under the Fair Credit Reporting Act. I know, I can already hear you saying, good grief, I just sent it to them 5 days ago. Why do I have to send it again? I don't know what to tell you other than this is our government bureaucracy at work. And in all fairness, we're talking about lawmakers who want to be sure the applicant is informed of his or her rights under the law. Listen, don't try to understand it. It'll make your head hurt. Just do it. Any professional background checking company like Background Checks Express will provide you with the forms that you need in order to be compliant. If you want to be FCRA compliant and stay out of court, it is vital you comply with these rules we've discussed over the past 4 videos. Next week, we'll take a look at least some of the lawsuits that have been filed against employers for FCRA violations while we've been reviewing how to avoid these lawsuits. If you're an employer, I hope you'll follow this series of videos, because what you learn here could well keep you out of court or keep you from hiring the wrong person. And that's our mission. If you have any questions about background checking, about the final pre-adverse notice, or want to find out how we can help keep you out of court and out of trouble, just feel free to call me at 844-SCREEN-NOW. That's 844-727-3366, or email me at sandy@backgroundchecksexpress.com. In the meanwhile, please be safe, hire safe, and I'll see you in the next video.